The final case of our morning call is Jerome versus Crum. It's a mini oral argument on the application, and each side has 15 minutes. Whenever you're ready, Mr. Desmond.
Good morning, Your Honors. Christopher Desmond on behalf of the plaintiff appellant Samuel Jerome. Chief Justice McCormick, if I may, I'd like to reserve 3 minutes of my time for rebuttal. I'd be remiss today if I didn't mention the fact that Mr. Johnson would have been here, but for the fact that I defeated him in the arm wrestling match to figure out which one of us was going to argue this case today. So that's why you have me in your presence. With that, I'd like to waive any remaining free fire period. I know we have a short, limited period of time today, so I want to be able to get to questions as quickly as possible.
Mr. Desmond, I'm going to take you up on that offer. Can you articulate for me what your gross negligence claim is? And I'm going to preface this by saying, I think this is true, and correct me if I'm wrong, but we have, based on what the federal district court and the Sixth Circuit have said, there was probable cause to arrest your client. The video or failure to disclose the video was not material to that finding of probable cause for arrest, correct? We may disagree, and you may disagree, and had we been deciding it in the first instance, maybe we would have an interesting discussion, but the federal courts have said that.
Well, Your Honor, my disagreement actually isn't just about the merits of that, your description of the finding. Okay. It's that description of the alleged finding in a whole. If you look at, and I think this is something interesting that I think has been missed at several levels now throughout the life of this case. The portion of the Sixth Circuit opinion that the majority of the Court of Appeals relied on was the section of the opinion discussing malicious prosecution. Mm-hmm. If you go and you actually read that section of the Sixth Circuit's opinion, the Sixth Circuit does not discuss the videotape at all in that section of the opinion. What the Sixth Circuit's actual finding was that the omissions that defendant Crum made, largely relative to his report, his written report, his omissions about the discrepancies between the May 7th interview and the August 21st interview, those did not play a material role in the probable cause finding. They were not talking about the revelation of the tape. They were talking about the omissions in the report. And I think that's important for a reason. If we're doing a collateral estoppel analysis, we have to figure out what the actual factual finding was that's at issue here. The factual finding that I just described, I think, is very different from a gross negligence standpoint than the way the majority of the Court of Appeals describes it. Because, and again, I don't think we should be bound by what the Sixth Circuit did in any regard in this case, but if this court were to say, you're bound by the fact that the Sixth Circuit said the omissions regarding the descriptions of the report, you're stuck with that finding. That still leaves us with the ability to talk to a jury in Michigan state courts regarding the withholding of the tape.
Did Judge O'Meara find that the withholding of the tape was material to probable cause?
Judge O'Meara did, yes. Judge O'Meara did reference withholding the tape. The Sixth Circuit did not. Okay,
and I appreciate your argument. So perhaps it was wrong to say that both the Sixth Circuit found that as well. But let's stay with Judge O'Meara's decision. There was probable cause to arrest your client, and the disclosure or failure to disclose the video was not material to that probable cause determination at the arrest or to bind him over for purposes of criminal prosecution, correct? So then, when that video is disclosed, we have two things that happen, right? You have the bond is reduced and he's released from detention or from jail, and eventually then the prosecution decides not to re-prosecute him, right? Would you agree with me, though, that at that point that the video is disclosed and there's a mistrial, that there's still, based on Judge O'Meara's decision, there still was probable cause for that prosecution?
So it's a very interesting question, Justice Kavanaugh, and it's something that I have been thinking about thoroughly the last couple of days. Based on your description, having to accept all of those factual premises, yes, I think you could conclude that there continued to be probable cause.
At the time the mistrial is called.
There's an interpretation of probable cause. Some of the federal case law in particular discussing probable cause from a qualified immunity standpoint, references the fact that where you have a complainant, you have testimony from an eyewitness who testifies and makes accusations against somebody, that by itself generally is sufficient to create probable cause. So there continued to be that eyewitness testimony in this case, right? The reason why I think that's important is because, and by the way, not dispositive of our gross negligence case, is because of the fact that just because you have probable cause does not mean that you elect to prosecute, right? Because under your description just now, there could still be probable cause today in someone's mind. I don't believe there is, but there could still be in someone's mind. The prosecutor, though, made the decision to not act on that probable cause. Probable cause is a fairly low threshold. You're simply saying that there's reason to believe that somebody committed a felony. Just because a prosecutor thinks there could be reason to believe it doesn't mean that a prosecutor is going to take every single case in which there's probable cause all the way through the course of a trial, because they could realize, yeah, there's probable cause, but we're never going to get a conviction in this case because of the following things. And the following things in this case, by the way, are the fact that Detective Crum conducted a horrific interview of this accuser in which he disregarded all forensic interviewing techniques. He guided her. He talked about, excuse the language, but this was his quote, needing to overcome the crap that the defense attorney was going to pull, talking about how he knows her mom is trying to coerce her into recanting her accusations. So he's disregarding everything that forensic viewers are told to do. So does the probable cause exist? Yes. Would the prosecutor decide to prosecute under those circumstances, knowing that their case is going to be eviscerated at trial? Obviously not, because they didn't in this case.
So, and I recognize that the fact that the prosecutor chose not to re-prosecute the charges would be, I think that's not speculation of why he didn't do it. That would tend to suggest that it did, in fact, have an impact. But wouldn't you, I mean, my problem was in looking at the transcript from the mistrial. One, the judge, and again, looking at that probable cause, I guess, determination, the judge didn't look at the video. The mistrial was premised on, or was because the officer had testified, the sister had testified, the complainant had testified, and now we have this video, and it was a fair trial issue, I think, and now we're going to have to try and redo all of this again. I don't see anything in the transcript about the mistrial that is tying the video or the failure to disclose the video or even what was in the video, other than some of what we see the defense counsel saying, to the fact of whether or not there was probable cause to maintain the trial.
So there was certainly an efficiency, a judicial efficiency and economy element to it. The fact that it was impractical to recall all of these witnesses and essentially conduct trial anew in front of this same jury, that was a portion of it. There were also statements, I believe, if I recall correctly, there were statements from the prosecutor that there are things within this video that would have been helpful to the defense and that the defense certainly could have used. So I think there was a content aspect of it as well.
Okay.
But again, Your Honor, I think that all of this is sort of playing into the initial error that the Court of Appeals made, which is it's focused on the idea of probable cause. That is not proximate cause. Those are two distinct and different concepts. And the reason why probable cause was such a focus at the federal level, having done a lot of malicious prosecution, false arrest, false imprisonment cases, probable cause is the issue, because it is the issue on which qualified immunity always hinges. So it's always a battle on our part, the plaintiff's part, to show that A, there was not probable cause, or B, if there was probable cause, it was the product of some act of maliciousness, essentially, and that's the language the Sixth Circuit used, a malicious, non-testimonial act by the defendant officer that led to a probable cause finding. So that is the issue that we were litigating in the Sixth Circuit. That's the issue that we were litigating federally. So when this court in People v. Trachtenberg talks about was an essential issue actually decided after being litigated, The issue of proximate causation was never litigated here. The issue of gross negligence was never litigated here in the Sixth Circuit. And as a practitioner, it gives me tremors thinking about what could happen in the future.
Sure. So, even
into,
if we were to agree with you under collateral estoppel, and I think that you make, a compelling argument that the issue of the officer's gross negligence or how to characterize his conduct may not have been decided by the federal court. The issue of proximate cause may not have been. How do you maintain a gross negligence claim in light of what was actually decided? In light of a finding that even at the time of mistrial, I think, there was probable cause, and as you suggest, maybe even today, there was probable cause to support the prosecution. How are you ever going to prove that your client had damages proximately caused by Officer Crum, given those findings?
Because
but even if they're not identical findings, isn't there a relationship that makes the causation complicated?
Well, respectfully, I don't think so. Because I think that what we end up showing is that the prosecutor's decisions to proceed with this case, to arrest, to imprison, and to maintain prosecution for a year's worth of time, the decisions to prosecute weren't based on whether or not probable cause existed, but were based on what did they think the evidentiary record was that they were going to have at trial. And had the prosecutor known from day one that this evidentiary record is going to contain a videotape in which our officer in charge of the case is essentially coercing an accuser to testify in a certain way in her fourth interview, that prosecutor could have decided before my client was ever arrested, we're not proceeding forward with this case. So regardless of probable cause, when I'm making a gross negligence showing in state court, I don't think I ever have to discuss probable cause in this case at all. I may have to discuss what the prosecutorial decision-making process was. Probable cause may be a portion of that, but it's certainly not the sole portion.
And that's completely divorced from the fact that the arrest was supported by probable, regardless of the video. Based on, you have a state district court judge who heard the testimony solely of the victim and said that I find probable cause to support the charges and to bind him over for prosecution. And that even given that you can still then go back into the decision to prosecute in the first instance and impose damages for the entire prosecution and detention throughout, regardless of the fact that you could maintain the action. So it could basically circumvent a federal wrongful arrest and malicious prosecution claim. You could get damages under state law, but not, and even though you're prohibited under federal law.
Absolutely, Your Honor, because under federal law, Congress elected through 42 U.S.C. 1983 to have certain exceptions to the governmental immunity that naturally exists. The state of Michigan chose to have different exceptions to governmental immunity, one of them being gross negligence. And so it was the policy choice of this state to allow someone like Mr. Jerome to pursue a gross negligence claim if they can meet the elements of that claim.
What about not to monopolize this, I apologize, but the state claims of wrongful arrest and malicious prosecution are also defeated by probable cause?
So there is overlap from an element standpoint between the federal claims and the state claims of false arrest, false imprisonment, and malicious prosecution. I think there are practical concerns of allowing collateral estoppel to apply even with those, where you have cases running in parallel at the same time. It's very problematic from a practitioner's standpoint, but I do think those claims are distinct from the gross negligence claim from a legally analytical standpoint.
Okay.
I know I've gone a little bit over what I was going to go. If anyone else on the panel has questions.
I have one question. Oh, you had a question?
Go ahead, please.
What do we, just shifting gears a little bit, the Court of Appeals had an alternate holding on causation, and I don't believe you appealed that holding. What do we do with that?
So the Sixth Circuit's alternate holding, I believe, was that even if collateral estoppel did not apply, that we could not demonstrate causation?
The Court of Appeals alternate holding is what I'm asking about.
Yeah, Your Honor, I'd have to go back and look at my initial application. I believe that we did address the causation portion of it. It may have been sort of subsumed in the collateral estoppel analysis where I was describing the way a gross negligence claim is distinct from any of the claims that were decided at the federal level, where I walked through what this court's causation analysis was in Ray.
I think I understand the merits of it. I was trying to ask procedurally whether it's, I'm not sure whether you appealed it to us.
I believe that I did, Your
Okay.
Honor, within that application. I would have to take a look at it again.
Justice
Well,
Markman has a question as well.
My question was exactly the same question that the Chief Justice asked. I also didn't see you respond to that argument. It was one that the defendant raised in the trial court and the Court of Appeals, and you did not respond at any juncture that I can see to that specific argument, to the effect that whatever the resolution of the collateral estoppel issues, summary judgment was appropriate because there was no evidence showing that Crum's actions were the proximate cause of your client's arrest and imprisonment. That would be remaining intact, wouldn't it?
Well,
Whatever we did in collateral estoppel?
Your Honor, so I believe from the outset of this case, going back to district court when we filed, or circuit court, I apologize, state circuit court, when we filed our initial briefing in this matter before collateral estoppel was raised in this case, we were arguing that there was evidence of proximate cause in the form of the fact that we have this direct prosecutorial response to the revelation of the evidence. That's something that I believe that we have maintained that argument throughout all of the proceedings here. But I do think that...
What if you didn't?
If it's not in front of this court at all, I think that this court has the ability to review what the Court of Appeals did in this matter in the sake of justice and fairness and making sure that there is an appropriate outcome in this matter, is what I would submit. I would also say, Your Honor, this is the preservation arguments that have been routinely made in this case are a little unwieldy compared to the ordinary preservation arguments that we see because of the fact that we've had this shifting time frame where when they brought their initial motion for summary disposition in state court, we didn't have a federal opinion yet. Yeah. Then, when we filed our initial appeal, we didn't have the very opinion, the Sixth Circuit opinion, that ended up forming the entire basis of the Court of Appeals opinion. So there's constantly been playing this mission of playing catch up and trying to anticipate what's going to happen in this parallel alternative forum, which goes back to what I was saying about these practical concerns about collateral estoppel when you have two active cases at the same time.
I don't doubt that yours is a difficult enterprise, but the Court of Appeals relied on two arguments, alternate arguments, not inconsistent arguments, but totally discrete arguments. And to the best of my recollection, only one of them was responded to. Of course, we'll scour the record to see what the truth of the matter is.
Thank you. I appreciate your
Thank
time.
you.
Thank you, counsel.
May it please the court, Mary Masseron on behalf of the defendant appellee, Lieutenant Crum. The judgment should be affirmed for three reasons. First, Crum raised collateral estoppel at the first opportunity in a written brief that was provided to Jerome days before the hearing in the trial court. And Jerome had every opportunity to respond either by moving to file a surreply, simply filing one, which is routinely done. I understand the rules don't allow it, but it is routinely done. And by providing argument which the trial court entertained without stopping him in any way, and he didn't. I did want to point out MCR 1.105 and this court's precedent make clear that rules are not to be applied on the basis of pseudo-technicalities. I think this court has used in some recent opinions, or as the court said decades ago, in a manner as a fetish, but to achieve substantial justice. So the argument with respect to the timing of raising collateral estoppel, it seems to me, is properly rejected. Secondly, collateral estoppel on the merits bars the action, as the lower courts correctly found, because both the district court and the Sixth Circuit held that Crum's non-disclosure of the video recording and his purportedly inaccurate account of inconsistencies between the victims' different interviews had no effect on the decision to bind Jerome over, that the prosecution and the defense were both aware of that at the time of the preliminary hearing, because the victim's testimony was consistent with the testimony in the video, which was only discovered later. In addition, collateral estoppel applies separate from the probable cause, proximate cause analysis, because the federal courts concluded that Crum was entitled to qualified immunity, and specifically said we could not find, do not find, therefore, that he acted in reckless disregard of the truth in his conduct. And it seems to me there's no way you could find on the basis of that, as well as on the basis of the criminal trial record, where the criminal court found Crum's non-disclosure until during the trial to be an innocent mistake. Both of those findings, it seems to me, make it impossible to find gross negligence under the Michigan immunity statute. And finally, the original motion was brought on the basis of Jerome's inability to raise a genuine issue of material fact with respect to whether his claims were barred by governmental immunity. The only one that's left is the gross negligence claim, and no evidence supports a finding that Crum acted in a grossly negligent manner. The testimony...
Ms. Masser, I'm sorry. I know my voice goes around the side. I'm wondering if you can help me out on this. And I recognize I don't think that we necessarily have this scenario in this case. But say that there's probable cause for the arrest. There's probable cause to bind the defendant over. At some point during the proceedings, information comes to the officer's knowledge or in his possession that would call into question that probable cause. And I understand the officer doesn't have an obligation to go seek out information to define or further bolster probable cause. But let's say it happens. And would the officer's failure to disclose that information, which doesn't change the fact that there was probable cause to bind him over at the initial stage, the failure to disclose information which might call into probable cause later on, could that form the basis of a gross negligence claim? Meaning his continued detention was caused by the office, and let's assume that it was grossly negligent. He knew it, it's sitting in his lap, he intentionally is keeping this away. He knows that this would get the charges dropped or at least get him out of jail, whatever it may be. He fails to turn that over. Let's assume that's gross negligence. Even though there was probable cause to bind him over, can a gross negligence claim be made out under those facts?
Well, I was initially thinking that the answer to that might be yes, but then you said he intentionally doesn't disclose it. And in that circumstance, we would be into the qualified immunity jurisprudence, which I understand all about Genesee County, but that jurisprudence still stands for the proposition that you can't take intentional acts and convert them into a gross negligence.
Okay, that's fair enough. So let's say he didn't intentionally. He just, with reckless disregard, failed to turn that information over.
And there's still probable cause?
There was probable cause to bind him over, but say a month, 3 months into it, information, evidence comes into his possession that would exonerate or would defeat probable cause, or would perhaps even at a minimum suggest that he shouldn't be held on bail and that he should be able to not be detained. Could that form the basis of a gross negligence?
I mean, certainly you could if you could show gross negligence and you could show that that gross negligence resulted in somebody's incarceration, in theory, there might be such a claim. I mean,
Isn't that one of the claims the plaintiff made? The complaint at paragraph 53B alleges in part that the defendant's gross negligence was the proximate cause of, among other things, the wrongful incarceration for 11 months. So I think the hypothetical Justice Kavanaugh is posing is what 53B alleges. I mean, your answer might be no matter what, they're not going to be able to show gross negligence. So that could be yet another reason to affirm the Court of Appeals, or a different reason to affirm the Court of Appeals. But hypothetically.
So certainly the plaintiff pleaded in the alternative gross negligence, intentional conduct with respect to
the continued incarceration.
The continued incarceration. And it seems to me the answer to that in this case is that the plaintiff failed to show at the summary disposition hearing any gross negligence. The evidence is all consistent that the officer went above and beyond. The officer asked 3 times for the records to be checked, for any videos to be produced, including after the
and I assume your client argued this in the trial court as well.
Correct.
There was,
and so there was no gross negligence, and that's clear on its face, even if the court doesn't want to rely on collateral estoppel. That alone defeats the claim. In addition, this court has said in Maiden and Smith v. Globe Life Insurance and many cases from this court and other courts that once a properly supported motion is brought, it's up to the plaintiff to rise up off his or her pleadings and come forward with evidence to create a factual dispute. And with respect to causation, all that there is speculation. There was no effort to submit an affidavit from the prosecutor. There's no deposition testimony from the prosecutor elaborating upon the decision. What we have in the record is a trial, my clients properly, immediately disclosing the video once he became aware of it, which he did not know, and then a discussion on the record in the criminal trial about the plaintiff in this, the criminal defendant, having been incarcerated for a long time, which creates a problem. I don't do criminal law, but I know there are deadlines that have to be met about how long you can keep someone incarcerated until the trial. That was a major issue in the discussions. There was a discussion about the need to recall various witnesses and the problems associated with that. There was a discussion about issues around the victim and her refusal to watch the Care House video, which was problematic in various ways, reflected her not to be perhaps as cooperative. All of these are potentially reasons. And in addition, there was a lengthy colloquy about the problem of double jeopardy and whether or not the trial court's decision that this was an innocent mistake and that there was a manifest necessity for a new trial, whether that was correct or not, with the criminal defense attorney calling that into question, consequently creating a potential appellate issue from any retrial. All of those are potential reasons for the prosecutor to have made a decision not to spend the resources on a second trial.
You make the argument, and I think that it's true, is that there's a concerns perhaps of how long he had been in jail, and the fact that we're now going to have to retry and continue to incarcerate him. But isn't it evidence on the other side, perhaps, that upon the disclosure of this video, his bail is significantly reduced. This judge looks at it and he's released from prison, or released from jail. So I understand that there may be other reasons, but is the fact that that this release of the video seems to be immediately precipitate an evaluation of whether he should continue to be detained, is that not competing evidence that is arguably that his continued detention may have been attributable to gross negligence. I understand your argument on gross negligence, but causation-wise,
I think the causation issue that the plaintiff is raising is whether the prosecutor would have brought the initial trial if the prosecutor had been aware that there was this video. And as to that decision, even if you reason backwards from the decision later in the case, it seems to me at best what the record shows is speculation between equally competing reasons not to have a retrial, and nothing to suggest that the prosecutor would never have pursued this with assuming that the prosecutor had the video at the outset. There is no evidence, no affidavit, no deposition, nothing to suggest that the prosecutor based that decision solely on the video and the potential that the criminal defense attorney could use portions of that video. And I don't know that the court has listened to all of that. You may have or you may not have. There were sort of statements made at the outset, which Crum described as his effort. I understand some other people might have done it differently, to put the victim at ease because she was being called back in again. This is a 14-year-old girl who was abused.
The video was very powerful, though.
Well, certainly the dissenting judge, whose opinion was impassioned and has a different view of the case than I do, felt that the video was very powerful. I listened to the video. I think it shows a series of questions, the questions as to Sabrina, the questions as to the victim, that basically confirms that she was sexually abused. And so I'm not prepared to say on the strength of the questions and answers in that video that alone, when we have no statement from the prosecutor, was the reason that the prosecutor chose not to retry, or even further removed from that at the outset before the prosecutor...
You don't think that we can infer it, though, based on the content, the way it was conducted, the essence of the case?
Judge O'Mara said that it wasn't. Right, it didn't
Absolutely.
impact.
Certainly
we might decide it differently if we thought that perhaps in looking at the video, even though Judge Wittenberg was relying, and the State District Court was relying solely on the victim's testimony, that had he been aware of the video and had seen the techniques, he might have been looking and reviewing the complainant's testimony differently, knowing perhaps that these techniques were still in play to have been affecting how she was testifying in front of him. But we sitting here now in this procedural posture we don't really get to make that determination because Judge O'Mara presumably considered that and said that it was not material to the probable cause.
Right. I think that's correct. And I think the collateral estoppel argument is a very strong argument that the district court specifically said Crum's omission of the inconsistencies and in a different place discussing the video was not material. And the Sixth Circuit affirmed that. So that alone defeats the claim. It seems to me that the plaintiff's claim can properly be defeated, was properly defeated in the lower courts on either of those grounds, both of which, in my view, are very strong.
Thank you, counsel. We're going to ask you some questions about FOIA now. I'm just kidding.
I would say about FOIA, that is a very interesting argument.
And I bet you have some helpful ideas.
I have a lot of thoughts.
I know. I was like, I just want to pull Mary up and ask her
I'm so
some
sorry, I can't add other, Sir rebuttal on that case.
Oh, no, Justice Markman has a question for you. Sorry.
Oh,
Ms.
Come back.
Ross,
Justice Markman has a question for you.
I have two questions, actually.
Okay.
I don't mean to beat a dead dog, but I'm a little confused about what you're saying about the alternative argument that punctuated the conversation that we had with the opposing lawyer. That alternative argument is specifically that there was a lack of proximate cause between what the prosecutor did and the results in this case. Was that raised by the appellant or not?
I don't think so, but I've been focused a little bit differently in my preparation, so I don't want to.
Okay, let me ask you another question in which both sides seem to be, both sides have engaged in at least what to me is some uncertain behavior. You have both applied federal common law in this context in determining the preclusive effect to give a federal court decision. I quote from Pearson, Sand, and Gravel, 1999 case of this court, "State courts must apply federal claim preclusion law in determining the preclusive effect of a prior federal judgment." This has been subsequently re-articulated in a number of Court of Appeals decisions. Haven't you briefed this case under the wrong legal framework and standard? And if so, what should be the response of this court? Or do you disagree with my premise that this was?
Your premise is that when applying a federal judgment, we should be using federal collateral estoppel.
Correct.
I don't disagree with that.
But you accepted the appellant's argument that it was state law that controlled.
We've argued it using primarily state law. I think that's correct. I don't think there's a difference in this case, so I'm not sure it makes a difference to the outcome.
Well, they're not identical standards. They're certainly not randomly related standards, but they're also not.
No, I understand. I understand.
The equivalent. Okay.
That's how we briefed it.
Thank you, counsel. Thank you. The case will be submitted. And that concludes our March case call.